for our children and their future and California's future. This bill is long overdue, in my opinion. They say that education is a great equalizer in our society, and what we are doing today will help level the playing field for countless young people in our state. I've enjoyed my time working very much with the Dream Team of the San Fernando Valley and the Dreamers of Mission College and many other of my constituents who desperately need, ask, and want just the opportunity to be able to fulfill their education hopes and dreams. I look forward to working with Mr. Cedillo and all the supporters of the California Dream Act to ensure that we finally win this fight for justice and equality. I urge a strong aye.
Thank you, Mr. Fuentes. Ms. Huber.
Thank you, Mr. Speaker. I rise in support of this bill. As a student who benefited from the generosity of private donors who gave scholarships to support me, I want to give back that opportunity to other students in California. My parents were on welfare when I was born, and we moved 10 times in K through 12. And I never would have had the opportunity to graduate from college if it wasn't for private donors who said, if you fit this biographical criteria, I'm going to support you, because I know how hard it is to try to struggle and be the first person in your family to graduate from college. So I want to give an endowment for that purpose, for those students. And what this bill does is it allows students who meet a certain biographical criteria to receive private dollars from donors that want to advance their cause. These are students who are already attending our CSUs, already attending our UCs, but don't have access to the private funds. And so to my more conservative members that are not supporting this bill, I ask you to think about that. This is about a donor's intent, that they want to give money to help someone graduate from college. Why would we stand in the way of that? I ask for your aye vote.
Thank you, Ms. Huber. Mr. Blumenfield.
I wanted to say a few words on that, not just because I think mine is the only mic that hasn't been up yet, but because this is a critically important issue, and I've been involved with DREAM Act issues for over 11 years. When I used to work for Congressman Berman, and he had one of the original precursors to the DREAM Act legislation that was based on some students who came into our office who had this problem. And it just kills me that we still, 11 years later, are still dealing with this issue. And the issue before us today is much easier than the federal DREAM Act in some ways. I'm 100% behind that. But one thing that I noticed that's a little different, which I'm hoping won't be here, is on the federal DREAM Act, when it came to the floor, it was bipartisan. There were Republicans who voted for it, and there were Democrats who voted for it. Because this issue really should be a bipartisan issue. It's not about traditional ideological Democrat-Republican issues. So my getting up is more of a plea to folks on both sides of the aisle to really think about this issue, think about doing what I believe and what many of us have expressed is the right thing, and I ask for your aye vote.
Thank you, Mr. Blumenfield. Seeing no further questions or debate, Mr. Cedillo, you may close.
Mr. Speaker, thank you very much for the opportunity and your stewardship of this matter. I'm very proud to be a member of this body, on this day, at this time. I thank all my colleagues for listening carefully, for your consideration. I know I've been here a long time, and I know that I've been carrying these issues for quite a while. And I know that sometimes it wears on your patience and sometimes on your tolerance, and I thank you for your consideration and your patience. I thank my seatmate for his tempered, though very firm comments, and I thank my other colleagues who don't necessarily share my perspective. Let me say first that many of you are absolutely right. Our system of immigration is broken. It doesn't work. It doesn't serve us. And that's a problem. It creates a dilemma for us. We want to do actions that are actually preparatory. And yet we know we cannot say with clear certainty when on a precise date that immigration reform will take place, when our laws will be fixed. And so that creates a dilemma for all of us. And I respect you, and I grant you that, because we all observe that. I've supported all the efforts in the recent years and worked very hard with the President Bush's administration to find a center area that we could have resolved immigration reform, and unfortunately we were unable to do that. I share your observation that, yes, at the beginning of the current administration, that there were majorities in both houses and there was an opportunity there that for various reasons didn't happen. That is a statement of fact. I don't have to defend that. But I do want to make a couple points to close, and again, I thank you. One, I think it's been very clear in this discussion that it is the law that these young students do have rights, and that they do have a right to education in this state at this time. And while it may be illegal to hire them, it is not illegal to educate them. And so I really appreciate the sports example that was brought up. I heard someone say, you know, I can take you to practice, I can let you prepare, I can do all those things, but I can't put you on the field yet. And that's true. But shouldn't we be prepared for that moment? Or should you just have your team sit on the sidelines and not be prepared for the moment when they are called to action? And so that's what this is. This is a call for preparation. Yes, you can't hire them today, but they should be prepared for when you can hire them. And that's what this bill does. I'm glad that someone I failed to note early on, and this bill doesn't cost the state 1 cent. Not 1 cent. I want to note to you the bipartisan nature of this movement, and the comments of Senator Tom Johnson, who spoke yesterday from Illinois, and he said, this is an American value issue. And in specific reference to the immigrant youth, he said, they are our future. They are our fellow residents of Illinois. And so I ask you, in the same bipartisan spirit, to recognize that this is, and these immigrant youth are our future. And they are our future, they are our fellow residents, and they are the future of California. Education, as we all know, for every single one of us, is the lifeblood of our democracy, and it is in many instances the reason that we have this incredible privilege and opportunity to sit on this great floor. Because for many of us, we were the first in our families through public education to have our lives transformed. I know that was my experience. The first in my family to graduate, to have an opportunity to get a state scholarship, to go to the great University of California in Los Angeles, to be able to stand here with you, because that's what education does. It changes our lives of our community, and puts us in this position then to transform the lives of so many. Let me close with a quote from the president of the University of California on this very point. He sent a letter to me, and he said that the outstanding accomplishments of these leaders of tomorrow should not be disregarded, nor their future jeopardized, simply because of their legal status. Mark Yudof, President of the University of California. Members, thank you so very much. I ask for an aye vote.
Thank you, Mr. Cedillo. The clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. All members vote who desire to vote. Close the roll, tally the vote. Ayes 51, noes 21. The measure passes.
Okay, members, we're going to continue with our third reading file item 56, AB 252. Clerk will read.
Assembly Bill 252 by Assemblymember Charles Calderon, an act relating to alcoholic beverages.
Mr. Calderon.
Yes, Madam Speaker and members, this bill corrects an error in a bill that was passed in 2009 by then Assemblymember Kevin De Leon. Had to do with the Tied House laws. It left out a group of small distilled spirit manufacturers that were otherwise supposed to be included, and so this bill simply puts them back in. There's no cost, there's no opposition. I ask for an aye vote.
Seeing no further questions or debate, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 68, noes 1. Measure passes. File item 59, AB 699. Clerk will read.
Assembly Bill 699 by Assemblymember Wagner, an act relating to non-probate transfers.
Mr. Wagner.
Thank you, Madam Speaker. Another bill that I hope is non-controversial. This one's gotten off the floor several times, only to find itself going into some trouble in the other House. We've made a couple of changes to satisfy those concerns. What this bill does is establish a non-probate method for conveying real property upon the death through a revocable transfer upon death deed. This is an estate planning device that is available in a number of other states, been used successfully for quite some time. The California Law Review Commission has urged us to pass this bill. Indeed, this House has done so unanimously a couple of times in the past. Sailed through committees with virtually no opposition. I ask for an aye vote.
Seeing no further questions or debate, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 63, noes 1. Measure passes. File item 60 on the amendments, AB 765. Clerk will read.
Assembly Bill 765 with amendments by Assemblymember Shajian.
Mr. Asajian.
Thank you, Madam Speaker and members. I rise to submit an amendment to add co-authors to AB 765. I request that these amendments go up to print and back on file.
Okay, we can take a voice vote on this item. All those in favor say aye. All those opposed say nay. The ayes have it. The amendments are adopted, out to print and back on file. File item 61, AB 1101. Clerk will read.
Assembly Bill 1101 by Assemblymember Engen, act relating to Teachers Retirement Board.
Mr. Eng.
Thank you, Madam Speaker. AB 1101 is a good government bill. It allows for a democratic process of representation on the CalSTRS Board, which is the nation's second largest public pension fund with assets totaling over $138 billion. Allows for direct representation of CalSTRS retired members and participates. Does not make any changes to the overall makeup of the board, including the state's constitutional officers or other remaining appointments. Under the governor, respectfully request an aye vote.
Mr. Mansour.
Members, I rise in opposition to this bill. While democratic elections are generally good, appointed representatives, especially for boards with narrow policymaking authority concerning fiduciary responsibilities, that is an effective method as well. Former Governor Wilson argued the point well in his veto of AB 2768 in 1998, stating that Proposition 162 established in the state constitution the responsibilities and priorities for STRS board members. As such, board members are responsible for representing the interests of the entire system, not just those of individual constituencies. Conducting elections to name special interest representatives would undermine this principle, which is why I voted no in the PERS committee. I urge your no vote. Thank you.
Seeing no further questions or debate, Mr. Eng, you may close.
Thank you, Madam Chair. Studies have shown that retired members are more conservative. They do not seek to raise their benefits, but rather to secure their benefits. They are the most interested in the oversight and accountability that we need under today's financial situation. Respectfully request an aye vote.
Clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 48, noes 22. Measure passes. File item 62, AB 1263. Clerk will read.
Assembly Bill 1263 by Assemblymember Williams, an act relating to the State Compensation and Insurance Fund.
Mr. Williams.
Thank you, Madam Speaker. Members, 1263 builds on existing efforts to create more transparency in the state fund. There have, over the past couple of years, been investigations audits and firings. And though no criminal charges have been filed, public confidence in the board is low. This extends the existing one-year prohibition on lobbying to 2 years in an effort to try to build up that confidence. Currently, the State Fund Board of Directors has the authority to hire and set the salaries for the Chief Financial Officer, Chief Operating Officer, and other staff. The board should also weigh in on any consulting contracts awarded to an individual who once held an appointed position with the State Fund. The bill passed out of Assembly Insurance with a unanimous vote. I ask for your aye vote.
Seeing no further questions or debate, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 70, no 0. Measure passes. File item 63, AB 195. Clerk will read.
Assembly Bill 195 by Assemblymember Roger Hernandez, an act relating to local public employee organizations.
Mr. Hernandez.
Madam Speaker and members, I present to you today AB 195. This bill addresses a gap in labor protections that currently exist in the Myers-Milius-Brown Act and the Educational Employment Relations Act, also known as the RADA Act. AB 195 would expand the protections for public agency employees regulated under MMBA with the same protections already provided to public education employees by the RADA Act. In 2009, 40% of 912,000 state employees were full-time California state employees. In order to protect workers' rights and to ensure fair working conditions for all state public agency employees, the MMBA established California's Public Sector Collective Bargaining Statute. Currently, although the MMBA does set forth a baseline level of protection for public agency employees, it does not provide a comprehensive enough list of unfair labor practices that public agency employers are prohibited from using. In striking contrast, the RADA Act sets forth a clear and comprehensive list of unfair practices that public educational providers are prohibited from using towards public educational employees. This bill would bring the MMBA into conformance with the RADA Act relative to unfair labor practices. The opponents of this bill would argue that this bill is unnecessary and duplicative, but I argue that this bill would ensure public agency employees are protected from other unfair practices that are not currently in the MMBA. AB 195 eliminates any confusion related to unfair labor practices and clarifies what specific acts against an employee constitute a violation of the law. The opposition would also argue that AB 195's prohibition around providing any unspecified inaccurate information is different and is broader than what is seen in the RADA Act. I argue that public agencies should be prohibited from providing any inaccurate information during collective bargaining because knowingly providing any inaccurate information during collective bargaining inhibits honest and open good faith negotiation. This is true whether you are a public agency, employer, or otherwise. We are currently working with the sponsor of the bill, AFSCME, and the existing opposition around the language on inaccurate information. Regardless of its financial resources or other important documents, AB 195 prevents public employers from giving out wrong and inaccurate information. Members, I respectfully ask for your aye vote.
Mr. Mansour.
Thank you, Madam Speaker. Members, I rise in opposition to this bill. AB 195 is an unnecessary codification and expansion of existing regulations that will create administrative and financial burdens for both the Public Employment Relations Board and public employers, which is why I voted no in PERS committee, and I urge your no vote. Thank you.
Mr. Allen.
Madam Speaker, fellow members, I rise in support of this measure. I can tell you as a labor law and employment law practitioner for 30 years that when MMB was adopted in 1968, there was no description of what were unfair labor practices. It left it to the courts to figure out what they were. They looked at private sector law. Even Justice Grodin provided some guidance, but it's been left undelineated for many years. Given the actions of the legislature to bring folks under Myers-Milius-Brown under the purview of the Public Employment Relations Board, PERB, having the unfair labor practices that are delineated by the RADA Act be aligned this way makes perfect sense. It will make it easier for the agencies and practitioners to decide what are the rights and responsibilities both of employers and the employer organizations. I urge an aye vote.
Seeing no further questions or debate, Mr. Hernandez, you may close.
Members, I ask for equity amongst all public employees. The protections are there for school public employees, should be there for all public employees. I respectfully ask for the aye vote.
Clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 50, noes 22. Measure passes. File item 65, AB 197. Clerk will read.
Assembly Bill 197 by Assemblymember Monning, an act relating to employment.
Mr. Monning.
Thank you, Madam Speaker. Members, I present Assembly Bill 197 regarding liquidated damages for minimum wage violations. This bill amends current law to provide that in a court action to recover unpaid minimum wages only, an employee who prevails shall be entitled to recover the unpaid minimum wages and twice the amount of unpaid minimum wages as liquidated damages. This essentially doubles the damages that will be assessed against an employer who fails to pay minimum wage. There's substantial evidence of widespread minimum wage violations in California, particularly in the underground economy, where payment in cash leaves no record of abuse. As budget constraints have contributed to the decline of the Division of Labor Standards Enforcement's ability to enforce infractions for minimum wage violations, it is imperative that deterrents are put into place to help motivate employers to abide by lawful minimum wage statutes in this state. A report published by UCLA in 2010 found that close to 30% of workers surveyed in Los Angeles County were paid below the state minimum wage. AB 197 is long overdue. 10 other states already provide for at least twice the amount of unpaid wages as liquidated damages. AB 197 parallels those state statutes, but it limits awards of liquidated damages only to minimum wage violation cases. The underground economy is flourishing. This bill does not go to law-abiding employers. I ask for your aye vote.
Seeing no further questions or debate, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 43, noes 21. Measure passes. File item 66, AB 240. Clerk will read.
Assembly Bill 240 by Assemblymember Bonilla, an act relating to employment.
Ms. Bonilla.
Thank you, Madam Speaker and members. AB 240 provides equity for minimum wage workers that have been victims of wage violations by their employers. In current law, a wronged worker may file a lawsuit in court and receive liquidated damages as part of their award. A worker may also pursue a complaint through an administrative process, but the law is not clear whether liquidated damages may be included in this administrative process. AB 240 clarifies that liquidated damages may be included if a worker pursues a claim through the administrative process. This process was established to provide a legal remedy for low-wage workers whose claims may not be sufficient to attract an attorney to actually file a lawsuit. I respectfully ask for your aye vote.
Seeing no further questions or debate, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 46, noes 19. Measure passes. File item 67, AB 147. Clerk will read.
Assembly Bill 147 by Assemblymember Dickinson, an act relating to subdivisions.
Mr. Dickinson.
Thank you, Madam Speaker. AB 147 expands existing eligible uses for transportation mitigation impact fees for transit, bicycle, and pedestrian facilities. I want to emphasize it doesn't impose or create any new fees. It simply allows local governments using the Subdivision Map Act to expand the applicable uses of the fees that are already imposed. Current law, in fact, limits the use of these fees for the mitigation of traffic impacts to bridges and major thoroughfares. And statewide efforts such as SB 375 and the development of regional sustainable communities strategies under that legislation encourage more compact growth and infill development in cities, existing urban cores, and urban unincorporated areas. However, cities and counties are facing many barriers when implementing infill policies, mainly the costs necessary to advance infrastructure improvements. Oftentimes, cities or counties can't widen existing roads or add additional traffic capacity, but they do have room to add pedestrian facilities, bus turnouts, or such things as bicycle lanes. AB 147 would provide cities and counties with greater flexibility to address transportation needs that are already triggered by new development. There's no opposition to the bill, and I would respectfully ask for an aye vote.
Seeing no further questions or debate, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 45, noes 22. Measure passes. File item 72, AB 820. Clerk will read.
Assembly Bill 820 by Assemblymember Gordon, an act relating to taxation.
Mr. Gordon.
Madam Speaker and members, county assessors, auditors, and tax collectors regularly charge fees for the services that they provide. One of those services is the preparation of a certificate of payment showing that taxes have been paid. These certificates are needed for a variety of reasons, including personal use, real estate transactions, for probate court, or the preparation of subdivision maps. State law currently sets the fee for this service, which is provided at the county level, and that fee is $1, an amount that has not been adjusted since 1947, the year that my seatmate was born. It is time to adjust this fee. It is also time to remove the state from this fee-setting process and allow county governments to set the fee for the service they provide. This bill removes the $1 cap and allows counties to set and charge a fee to cover actual costs incurred for the research and preparation of a certificate of payment for taxes paid. County boards of supervisors routinely set fees for actual costs. This is done through a public process with public notification and opportunities for public input under regulations established in the Government Code. It is critical that we give local governments the flexibility to charge actual costs for optional services so that all taxpayers are not forced to subsidize these services. AB 820 is a good government bill, and I urge an aye vote.
Mr. Donnelly.
Thank you, Madam Speaker. Members, I rise in opposition to this bill. This bill does nothing to address the true problems in the state of California, which is the impediment to employers actually hiring people. We have so many regulations. This is just one more. It doesn't make any sense to actually charge people more who can't pay the taxes right now. We ought to be looking for measures to reach out to people and maybe mitigate what they owe so that they can pay something. Maybe look at some sort of amnesty to those who are behind, because in most cases they're going to lose their homes, and that's it feels like we're piling on people who are already in a desperate situation. I urge a no vote.
Mr. Norby.
I think the bill is reasonable. Most fees, like almost everything else, are adjusted by COLA, cost of living, to account for inflation. $1 today is not what a dollar was in 1947. So I think allowing counties to raise fees based on inflation and building in some kind of inflationary trigger is reasonable. We do it in almost everything else, and those areas that require an affirmative action to do it become very, very cumbersome. But there ought to be some kind of automatic device here to make sure that the fee is reasonable cost recovery for the counties rather than setting it into law. I've had a number of bills which have gone before the Elections Committee which are doing something similar in terms of campaign contributions, reportable contributions, dollar amounts for conflict of interest that have to reflect the dollar amount reality of when the bill was originally passed and need to be adjusted through time. So I don't see this as an increase, but simply a long overdue adjustment which should be reasonable and which shouldn't be codified into law in terms of a dollar amount, but adjust according to the relative value of that dollar.
Seeing no further questions or debate, Mr. Gordon, you may close.
Again, members, AB 820 is a good government bill, and I urge an aye vote.
Clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 48, noes 20. Measure passes. Members, we're having some technical difficulties. The floor system, the voting system, is not in sync with the laptops. So we are trying to fix that. Your patience is appreciated. Doesn't affect your votes at all. File item 78, AB 1203. Clerk will read.
Assembly Bill 1203 by Senator Mendoza and others, an act relating to public employee organizations.
Mr. Mendoza.
Thank you, Madam Speaker. Members, I'm here to present AB 1203, which seeks to ensure representatives of employee organizations have time off to represent their members in employee relations matters. AB 1203 also requires that school and community college districts be reimbursed for the cost of granting release time to classified employees who do not hold an elected position in their union. Under current law, representatives who want to testify or represent their union in grievance adjustment proceedings before the Public Employee Relations Board do not have a clear legal right to do so. We need to ensure that public employees in our cities, our counties, our special districts, and school districts have the right to participate in union work when it is necessary. Members, I respectfully ask for your aye vote.
Mr. Allen.
Mr. Speaker, fellow members, I rise in support of this measure. This will simply clarify the law regarding release time for these employees. It also clarifies that the union can pay for that release time. I would also point out to you that not only does it help the organizations for collective bargaining, but it also helps them for shared governance at their institutions, which was a legislation passed a number of years ago. So it effectuates that purpose as well. I urge an aye vote. Thank you.
Mr. Mansour.
Thank you, Mr. Speaker. Members, I rise in opposition to this bill. The right to an approved leave of absence while engaging in union activity is subject to collective bargaining, and this should be considered together with other compensation items in the collective bargaining process. An employee who takes a leave of absence to engage in union activity should not receive any service credit for that time, and local agencies should not be required to pay individuals who are acting on behalf of a union against the interests of the employer and the taxpayers. I voted no in PERS committee for these reasons, and I urge your no vote today. Thank you.
Mr. Wachowski.
Mr. Speaker, thank you. I stand in support of 1203. I supported it in PERS. It's a common sense measure. It allows the union to choose the representative that would go to the meeting, and it allows the school district and the community college to be reimbursed for the time that that person's off. I urge members to vote aye.
Mr. Hagman.
Thank you, Mr. Speaker. And question of the author, please.
Without objection.
I'm just wondering, is there any limitations on the amount of time? I see in the language it's reasonable. Who makes the determination what's reasonable? What kind of outer box limits is this?
Well, it's reasonable in the sense that if say the employees have to go before the PERS board and the hearing gets carried over the next day, and then it might be 2 days, whatever the hearing's about, whatever they're there to testify and be part of, that's what reasonable means.
It's strictly for the PERS board hearings, not for other organization activities, no other negotiation or anything like that.
It depends. No, it could be on anything, because sometimes you call employees to testify on other things, and sometimes the officers of that union don't have that expertise, the experience, or have not gone through that. So they find an employee who has, and then they go and testify of their particular experience with that particular matter. So it varies. So it could be for any particular union work, but that's the purpose of this bill is to reimburse the community college and school districts, so that way they don't incur any costs.
Thank you on my own time, Mr. Speaker. I would have to agree with I have to vote no on this as well. Without some of those limitations put in the system, and this is usually the details that is worked out through collective bargaining, I think we're superseding that procedure when we should look at training, the labor negotiations, everything else in those contracts, and this should be included in those.
Mr. Mendoza, you may close.
Members, again, it's unrealistically and very punitive when you expect members of unions to go testify before special boards and then they have to lose compensation or they have to lose benefits for doing so. This gives the union the opportunity to reimburse the school districts and keep this employee whole and not be punitive in that sense. So with that, members, I respectfully ask for your aye vote.
Clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll. Tally vote. Ayes 47, noes 22. The measure passes. File items 79 through 81 pass and retain. File item 82, AB 712. Clerk will read.
Assembly Bill 712 by Assemblyman Williams and Act relating to recycling.
Mr. Williams.
Good afternoon. AB 712 prevents a local government from receiving state grants for recycling funds if they prohibit a supermarket from siting a recycling facility. Current law requires all supermarkets in the state of California to cite recycling facilities as the recycling facility of last resort. But it is the case, however, that some local governments, largely for aesthetic reasons, have been prohibiting the ability of them to site such a facility in their parking lot or outside their facility. That leaves them with only one opportunity or one choice, and that is to put it back into the store. You can imagine, members, the problem of siting a recycling facility inside a grocery store with food about. That's a disease vector that creates a whole lot of health and safety problems. And AB 712 does not change a supermarket's responsibility to take containers back into the store, but local governments shouldn't interfere with a supermarket's ability to comply with the law, and this would at least deny them recycling funds if they interfered with the supermarket's ability to comply with the law. This is pro-business and also pro-recycling, members, and I hope you will give me your aye vote.
Mr. Chesbrough.
Yeah, thank you very much, Mr. Speaker. I rise in support of this bill. We voted it out of the Natural Resources Committee because California has achieved a 57% waste reduction goal. The law says 50%. We've achieved 57%. Hopefully we'll continue to work our way upwards on that number. And that's because of several laws that this legislature passed in the past, AB 939, which mandated the 50%, but also the beverage container law. And those two laws work together to effectively put California in the forefront. And we cannot allow going backwards. Communities have a responsibility to help compliance with the law. We need to have these drop-off centers so that we can continue to have the deposits collected and the beverage containers returned. I urge your aye vote.
Seeing no further questions or debate, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the vote. Ayes 69, noes 0. The measure passes. File item 83, AB 230. Clerk will read.
Assembly Bill 230 by Assemblyman Carter and others, an act relating to joint educational programs.
Ms. Carter.
Thank you, Mr. Chair and members. Assembly Bill 230 would assist students in middle college, high school programs in meeting their unique educational requirements, which includes enrollment in community college level courses by eliminating their status as part-time or full-time special students. There are over 38 middle college and early college high school programs in California. These schools are dedicated to providing historically underserved students with the opportunity to earn a high school diploma in a college environment, leading to either an associate degree or up to 60 units toward a college-level degree. AB 230 will not give these students priority enrollment. The bill will just provide them equal access to the classes they need based on their unique and successful educational model. Now respectfully ask for your aye vote.
Seeing no questions or debate, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the vote. Ayes 72, noes 7. The measure passes. File item 84, AB 23. Clerk will read.
Assembly Bill 23 by Assemblyman Smythe, an act relating to local government.
Mr. Smythe.
Thank you, Mr. Speaker and members. This bill is the first in a series of legislation that you'll see from all members of this body that has come about from the City of Bell scandal that we all read about last summer. And we hope that these bills will help close a lot of loopholes that were exploited and help bring more transparency and openness to our government process. And one of the ways that the folks at the City of Bell took advantage in padding their salaries was they would host a series of serial meetings, in that they would have their agenda item, and then they would open up 4 or 5 meetings in a row where they would just gavel down, call the roll, and then close it. And for each one of those meetings, they were receiving close to $1,000 a pop. And so what this bill is going to do is help to close that loophole by requiring that anytime a city council wishes to have back-to-back meetings, the clerk or presiding officer would have to announce how much each council member would be making as a result of these meetings. This way, councils that those of us that have served in local government, we've done this before whether you're going to a redevelopment or you're on a parks committee. That doesn't preclude you from doing that. It just helps alert the public the compensation. Most cities, there is no additional compensation for serving in that concurrent form. Again, however, the city of Bell chose to take advantage of that. The bill's got bipartisan support. Ask for an aye vote.
Mr. Lara.
Thank you, Mr. Speaker. Members, I rise in support of this important bill to ensure we have transparency in honest local governments. I urge your aye vote.
Ms. Torres.
Thank you, Mr. Speaker. Question of the author.
Without objection.
As we know, local water boards, they get on an average of $100 for attending a breakfast that is paid for on their behalf by the board. And oftentimes, because these water boards are not very highly attended by the public, all of these fees to the taxpayer become silent. Does this bill address that?
It's silent on the issue of waterboarding. However, and to be clear, the bill does clarify again on the compensation when it is like actual costs, whether it is for travel, food, lodging. That is it remains the same. So the bill doesn't address that. So again, it's simply if there would be multiple meetings on the water agency, if they then adjourn to also become another subcommittee of the agency, the clerk or presiding officer would still have to announce the compensation they would be receiving regardless of what it was.
I support your bill, and I would like to see it move forward, but I would also like to maybe work with you in ensuring that water boards also have to abide by some type of disclosure.
Very good.
Thank you.
Thank you.
Mr. Alejo.
Mr. Speaker and members, I rise as the Vice Chair of the Assembly Local Government Committee in support of this bill and a series of bills that we will all be hearing these next few days as a package of legislation trying to address the concerns not only City of Bell, but it's a lot of other cities, a lot of other bodies probably having similar problems. We heard not just a few days ago about what's happening in the city of Vernon as well. So this bill would provide that type of transparency and that accountability that the public has been asking for in light of what has gone on in other cities. And I want to ask all of you to support this legislation today.
Mr. Smythe, would you like to close?
No, thank you. I think my colleague from Watsonville closed perfectly. I ask for an aye vote.
Clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the votes. Ayes 68, no 0. The measure passes. File items 85 through 89 pass and retain. File item 90, AB 835. Clerk will read.
Assembly Bill 835 by Senator Mitchell and others, an act relating to community colleges.
Ms. Mitchell.
Thank you, Mr. Speaker and members. I'm happy to present AB 835, a measure which calls for better coordination between career technical education programs, high schools, and community colleges in order to maximize student participation. Studies have shown that students who complete such courses are significantly more likely to pursue higher education and to have higher paying careers. AB 835 removes administrative barriers that have prevented students from diverse geographic regions from participating in in-depth career exploration to gain marketable skills that will assist them in developing a career upon graduation. This bill has enjoyed bipartisan support in both Assembly Higher Ed and Assembly Education Committees and has received no votes. I respectfully ask for your support today.
Mr. Donnelly.
Thank you, Mr. Speaker. Members, I stand and urge an aye vote on this bill. Anything that removes barriers to breaking the logjam in education, I'm in favor of, and I commend my colleague for bringing this forward. I urge an aye vote. Thank you.
Seeing no further questions or debate, clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the vote. Ayes 69, no 0. The measure passes. File item 91, pass and retain. File item 92, AB 470. Clerk will read.
Assembly Bill 470 by Assemblymember Halderman, and Act relating to air pollution.
Ms. Halderman.
Thank you, Mr. Speaker. By allowing the use of existing funds for retrofitting school buses for emissions control, AB 470 adds another option to improve children's health and also to ease the fiscal burden on our schools. It adds a cost-effective and flexible option, but it doesn't remove other options, such as replacement of school buses. There's no fee, there's no mandate, and AB 470 passed unanimously out of the Transportation Committee. I'd like to express my appreciation to Chairman Lowenthal and her staff for her support and also the assistance with the language. I respectfully ask for your aye vote.
Mr. Hagman.
Thank you, Mr. Speaker. And Dr. Halderman, is this your first bill?
I plead the Fifth Amendment.
Well, I believe it is. And I was going to ask you, what do you have against the older school buses here?
Age discrimination is unacceptable in any form, including for those of you under 40. Those of us over 40, it actually is not consistent with the California Constitution, so I am not discriminating.
You're not discriminating against
No,
the
sir.
older buses? Because it has to be 15 years or older buses for this to work with, right? So we're putting those new bus manufacturers, those employees, out of business.
No, actually, some of them are going to have an opportunity that they did not have before, which is fabulous for the California economy, and I urge your support.
You definitely have it. Good job.
Mr. Donnelly.
Permission to ask a question of the author?
Without objection.
Ms. Halderman, I understand that you're in favor of freedom, and yet doesn't your bill include a trap on the school bus? Are you trying to trap the children?
The children would remain free with all constitutional protections, but the polluting emissions would be trapped by these devices, which could then be funded if the bill passes.
Thank you. I urge an aye vote.
Mr. Wagner.
You can't object when somebody asks if they want to ask you a question. Our analysis indicates a question of the author.
Without objection.
Dr. Halderman, our analysis indicates that this is an existing fee, and you are directing the districts to use the last $2 from the $6 specified fee. Is that correct?
That is correct. It is
Can I
currently
ask-
only used for replacement of school buses.
I understand, but my question is this. Why the last $2? What's wrong with the first $2? Or if the district wants to use the first and the third dollars, why are we mandating the last two?
I think you raise an excellent point, and I am very happy to work with you in the future on such language.
Thank you very much.
Mr. Miller.
Thank you, Mr. Speaker. Permission to ask a question of the author.
Without objection.
Dr. Halderman, does this bill have anything to do with the wheels on the school bus?
The wheels certainly would be included in this bill. They go round and round.
Touche. Very good.
Mr. Hall.
Mr. Speaker, question of the author.
Without objection.
Thank you. It's my understanding that this would preclude undocumented students. Is this bill for both documented and undocumented students?
The role of the school bus is to provide safe transportation without discrimination against a single child in the state of California.
So the question is this for both documented and undocumented students?
All students carrying a backpack have documents in those backpacks.
No. Legally documented or undocumented students?
I appreciate the question, Mr. Hall, and will require further study.
So now you're discriminating against documented or undocumented students, or is this for documented and undocumented students?
Well, as I explained, these are in fact all documented students given what they carry in their backpacks.
So if documented and undocumented students are not going to be, or undocumented students are not going to be allowed, how can I support this? Because I don't believe in discriminating. From what you said earlier to the other member of the floor.
I think you should vote your own conscience, Mr. Hall, and I would never presume to tell you how to represent your constituents.
So then if undocumented students then are not allowed on the bus. Right. So let me, exactly. Are illegal aliens allowed to be on the bus?
It depends from which planet. If it's Pluto, I think there's some questions of astronomy, because we now know it's may not be a planet, and I think that's an issue for Legislative Council.
If illegal aliens and undocumented students are not allowed to be on the bus, then I will respectfully ask for a no vote. Because indeed you are throwing them under the bus.
Thank you, Mr. Hall.
Ms. Mitchell.
Yes, Mr. Chair. Point of clarification. Is it the rule of the House to allow freshmen to haze fellow freshmen?
Ooh, the point is well taken. Who was the freshman that...
Well, I'm standing in defense of my fellow freshman classmate, and I think there were fellow freshmen who stood. Mr. Wagner, there were other fellow freshmen who hazed her. So I just wanted clarification of the rules of the House.
So I am going to rule that Mr. Wagner was out of order?
I would appreciate that. Thank you very much. Mr. Donnelly as well. He too is a member of the freshman class.
Mr. Donnelly was out of order. Mr. Swanson.
Mr. Speaker, I just wanted to rise and say how proud I am to learn that Dr. Haldeman is smarter than most men in this chamber.
And last but not least, Mr. Amiano.
Oh, no. Question of the author.
Without objection.
Yes, in terms of low emissions, I have a question about the LGBT community. Are you supporting the Queen House effect?
It depends. This bill actually does, though, contain provisions that cover both diurnal and nocturnal emissions. So,
all right, I'll leave that. And a tip of my tiara to you. I urge an aye vote.
Okay, seeing no further questions or debate, Ms. Halderman, would you like to close?
I respectfully ask for your aye vote.
Clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the vote. Ayes 68, noes 0. The measure passes. File items 93 through 97 pass and retain. We're going to move out of order to file item 47, AB 485, for purposes of amendment. Clerk will read.
Assembly Bill 485 by Assemblymember Ma with amendments.
Ms. Ma.
Thank you, Mr. Chair. These amendments address two special fire districts in California, one in Contra Costa County and one in Los Angeles County. These fire districts are organized as separate taxing entities but governed by their respective county board of supervisors. These amendments would simply require that in these jurisdictions that the board of supervisors take two separate actions to participate in an infrastructure financing district, one as their role on the board of supervisors and one as their role on the governing board of their respective fire districts. Respectfully ask for your aye vote.
Okay. Any question or debate on the amendments? Okay. Any objection to a voice vote? All in favor say aye. Opposed? Ayes have it. Out to print and back on file. Mr. Calderon, you are recognized.
Wanted to, first, at the request of the author, please remove file item 105, ACR 35 by Hernandez from the second day consent calendar.
Clerk will note.
And then I also want to announce, before we adjourn, that at the end of this session, there are a number of committee meetings that will meet, and they are as follows. Accountability Administrative Review in room 437 on AB 273. Budget Subcommittee number 6 in room 4202 over a number of measures. Higher Education in room 444, Natural Resources in room 126, and Public Safety in the Rules Committee upon the adjournment of session.
Okay, we're going to now move to the second day consent calendar. Does any member wish to remove an item from the second day consent calendar? Seeing none, clerk will read.
Assembly Bill 348 by Senator Buchanan and others, an act relating to highways.
Clerk will open the roll. All members vote who desire to vote. All members vote who desire to vote. Clerk will close the roll, tally the vote. Ayes 67, no 0.
Assembly Bill 1026.
Ayes 67, no 0.
Assembly Bill 1281.
Ayes 67, no 0.
And Assembly Bill 853.
Ayes 67, no 0. The consent calendar is adopted. We're going to now move to announcements and adjourn in memories. The following member was previously granted permission to speak on adjourn in memory. Mr. Hagman? Yeah. Mr. Hagman, do you have an announcement? Yeah, no? Mr. Valadeo, do you have an adjourn in memory? Ms. Brownlee, do you have an adjourn? Ms. Brownlee.
Thank you, Mr. Speaker. Members, with deep sadness, I rise to adjourn in memory of Marie Panic. Marie was a close friend and a constituent who was a resident of Oak Park in Ventura County for over 20 years. She died unexpectedly Tuesday of a brain aneurysm at the age of 57. Marie Panic served in the Peace Corps in Ghana, West Africa, where she taught chemistry in secondary school. She also taught at Moore Park College for more than a dozen years, where she served as Life Sciences Department Chair and as co-chair of the college's curriculum committee. She taught for many years and then settled down to have a family and volunteered in her daughter's elementary school. In 2002, Marie was elected to the Oak Park Unified School District Board and subsequently served 2 4-year terms. She was serving her 3rd term at the time of her death. More recently, Marie served on the Board of Community Action of Ventura County, which provides services and outreach to the low-income community and the homeless. Last year, Marie sought the Democratic nomination in the 24th Congressional District. Marie's experience, courage, and longtime commitment to the education needs of our communities have served our constituents well. Please join me in extending condolences to Marie's family, including her husband, Alan, and her daughters, Alicia and Michelle, at this time of great sadness for her family. I adjourn in memory.
Thank you, Ms. Brownlee. Please bring that name to the desk to be printed in the journal. Quick announcement, very important one though, just a correction on the meeting of Budget Subcommittee number 6. It's going to be at 12:30, not upon adjournment. So just to repeat, Budget Sub 6 is going to be at 12:30 today. Session schedule is as follows. Friday, May 6, no floor session, no check-in session. Monday, May 9, floor session at a time to be determined. All other items remaining shall be passed and retained. All motions will be continued. I am ready to enter. Not quite ready. No. Session schedule is as follows. Monday floor session will be at 12 noon. Okay. Now I'm ready to entertain a motion to adjourn. Mr. Allen moves, Mr. Calderon seconds, that this House stand adjourned until Monday, May 9 at 12 noon. Quorum call is lifted.
Vote change, Knight, AB 1101, file 61, from no to aye.
Councilmember Knight, AB 1101, no to aye.